Dr. Garsanbhai, members of the faculty, Dr. Purvi, Mr. Singh, retired judges of the Supreme Court, of the High Court, the Advocate General, friends and young friends who will soon join the bar. It is indeed a great pleasure for me to have come here, and I would say Mr. Shellert is responsible because he used to speak to me for coming here, and I am happy that I took out some time to come here. I never imagined that there would be a complex of this type. Even though we come from Delhi, we have seen big complexes, but I have personally not seen a private complex like this spread over 100 acres, full of green, enthusiasm, young people, nice buildings. It gives a very pleasing feeling to come here, and I am sure that students who are studying here are also having the same feeling. I am also very happy to note that this university and this institute is closely connected with very senior and distinguished lawyers and judges whom I find here. And it is only with their interaction that you students will gain a lot. And I must say, to my disappointment, that we have been students of the Delhi University, but the university there and the city there is so big that it has become like an ocean. Nobody goes back to the university, there is no interaction. And the first thing I'm going to do is to speak to the Vice Chancellor when I go back, to have these kind of interactions. We have a vast number of students who are now lawyers in Delhi, who have become judges of the Supreme Court. Chief Justice Sabarwal was a product of the same university. Chief Justice Kirpal was a product of the same university. And yet, we don't have the interaction which I find here. So I must say that this is a model which should be followed elsewhere. Now coming to the topic, Judicial Commission and reform. This is a topic which is much discussed, much debated. And as you would have noticed, not only in legal circles or in courts between lawyers and colleagues and judges, it seems to have become a topic which has caught the fancy of the nation. When this case was being argued in the Supreme Court, starting in May and then June and then July, the extensive reporting in all newspapers, including electronic media, was such that it showed that the country was looking up to this monumental issue. What will be the verdict? How it is going? Which side is arguing what? All the states were before the court. The union was before the court. All exchanges between the judges, individual judges and lawyers was very widely reported. So it is a very, very live issue, if I may say so. The issue really arises from the fact that there has been criticism in the past about the current system, which was called the collegium system. And in fact, there was criticism even of the first system, which started with the advent of the Constitution in 1950. The first system prevailed till 1993. The second system went on from 93, devised by the second judge's case, till 2015, when the third system has been put in place, namely replacement of the second system by a constitutional body. Now, a lot of people say that one system was good, some say the second was good, some are doubtful whether the third will be good. Whether it will be good or it will not be good will only be seen after it is put into place. Regretfully, it could not be put into place because petitions were filed even before the law was notified. And petitions were pending, so the system hasn't really taken off. But in a nutshell, I will go to each of the systems. But I must tell you that the Constitution was amended by the 99th Constitution Amendment Bill, and an act was passed simultaneously, which is complementary to the Constitutional Amendment. The act is called the National Judicial Accountability Commission Act, NJAC. Both have been passed as a package. The Constitution Amendment replaces the erstwhile system of the collegium, a collegium of judges which was coined and established by the second judge's case. And in its place, it established a commission. The commission would be an independent constitutional body. It would have 6 members: Chief Justice of India, 2 senior-most judges after him, the Law Minister, and 2 eminent persons. So 6 of them would form the commission. How they will actually function is provided in the Act. The Act prescribes details and procedures. But one important thing was said in the Constitution when it replaced the old system, that one of the 2 eminent persons must be from a class of persons like SC, ST, women, and other socially disadvantaged classes if necessary, so that a proper perspective, even from their angles, is put before the commission. So this is how this commission was to examine. The commission has not started because the 2 eminent persons who have to be a part of the commission have to be selected by a 3-member body which comprises of the Chief Justice of India, the Prime Minister, and the Leader of Opposition. So these 3 have to meet to select 2 eminent persons. As a matter of fact, when this law was promulgated, the Chief Justice of India was invited by the Prime Minister to sit along with the 3rd member, the Leader of Opposition, so that selection of 2 eminent persons can be made and work can be started. But the Chief Justice declined to sit, saying that the case was pending. Right or wrong, the fact remains that the commission could not start its work because it could not be constituted. And that is a position that has been obtained for the last couple of months. We are all aware that there is great shortage of judges. Judges are retiring. New judges are not being appointed because of this imbroglio. And as you are aware, this case was argued in May, in June, in the vacations, in July. Judgment was reserved after 32 days of hearing by a bench of 5 judges. And I hope that the judgment will come sometime in about 4 weeks from now, so that one way or the other, the country knows where we stand, and the system of appointment of judges must go on one way or the other, and that's how we should look at this. Now I must tell you, it is not as if that this government for the first time, as some people criticize, that the government came in the month of May and the first thing they did in August was to replace the system, as if to show that there is antagonism between the government, which came with a thumping majority, or with the Supreme Court. But that is not so. There is no case of or question of antagonism at all. Right from 1981, as a matter of fact, in the first judge's case, Justice Bhagwati said that a time has come maybe to have a commission. Just like Australia and New Zealand were contemplating a commission, so that power is not vested in one person, but is broad-based. This happened in 91. Then came 1990. 1990 was a case where the government introduced a constitutional amendment to form a judicial commission, akin to what has been formed now, but with some variation, but with a predominance of judges. That bill was moved, the 67th Amendment bill, but it lapsed, it couldn't be passed, there was no sufficient majority. This was preceded actually in 1987 by a Law Commission report, which also suggested that we should have a judicial body with predominance of judges. The idea was to have different people voicing their concerns from different walks of society, to have, as they say, a whiff of fresh air, or as they say, sunlight is the best disinfectant. So let it be widespread, let people come and give views. Then came, in 97, Justice Venkatachalaya was appointed as the chairman to review the working of the Constitution. He also came up with a model. His model was moved in 2003. His model was 3 judges, law minister, and 1 eminent person. But by this time, the second judge's case had come, and I will go into the history a little later. The second judges came in 1993. The second judge's case created, if I may say so, with respect to the court, or legislated, and by legislation it amended Article 124 of the Constitution, which provided for appointment of judges. But I will come back to it just to complete the history as to how this issue is being debated for the last 25 years. Finally, the 2003 bill also could not go through. Then the last bill was in 2013 by the UPA government. That bill also had a provision of 6 members. Same constitution as the current constitutional amendment. 3 judges, 1 law minister, 2 eminent members. But the 2000 bill also lapsed, it didn't go through. It is in this context that the introduction of the constitutional amendment in August, along with the NJC, must be seen. So that one notices that a dispute or differences which have been going on for so many years between different political parties of different hues, suggesting slightly different models from each other, finally fructified in 2014. And that is how these bills were passed. As you are aware, a constitutional amendment of this type requires a different procedure to be followed as opposed to amendment of a statute. Amendment of a statute requires only a simple majority in Parliament, while amendment of a constitution of this nature requires a 2/3 majority. If you read Article 368 of the Constitution, you will find that you require 2/3 majority and ratification by half the states in the country. The reason is that this kind of amendment will affect recruitment to the High Court. The High Courts are situated in states, and therefore the state's consent is also required. Or more than half the states gave their consent, and finally the laws were promulgated in December, but they were brought into force by a notification only on 13th of April 2015, by which time a challenge had already been filed in the Supreme Court. As you are aware, one of the most important things in the judicial system is the quality of judges. Quality of judges to some extent must depend on the manner of selection. There is a debate whether independence of judges comes only after appointment under the Constitution, or independence is to be seen in the process of appointment itself. In many Western countries, the appointment is not by judges, not even by a body with majority of judges, but there is majority either of the executive or parliamentarians. And there the concept is that independence of judges really comes after appointment, which means that when a judge is appointed, he cannot be removed at the whim and will of the executive. So we have a procedure of impeachment. The procedure of impeachment is very elaborate. It is not easy. It is cumbersome. Hardly a judge has been impeached in the last 50, 60 years. We have fixed salaries of judges. Service conditions cannot be changed to their detriment. These are elements, as most people argue, important for independence of the judiciary, including the factum of pension, etc. But it is also argued that the manner of appointment of a judge will also come within the fold of independence of judiciary. So the manner of appointment has to be such that it is transparent, it is reflective of responsibility. Now, whether this process of appointment should be only within the judiciary, should it only be with the executive, should it be with parliament, or should it be a mix of the three wings, is the real question. As I have told you, before we go into how judges were appointed in India at different periods, it is necessary to inform the students here that in America, the system of appointment is completely political. An appointee has to pass muster of the Senate, and only then he can be a judge. So they don't think that judges must appoint judges, and only then will the judiciary be independent. Take the UK for example. UK now has a commission which is comprised predominantly of what they call lay persons. They are not even eminent, just lay persons, ordinary people. Could be the owner of a hotel, could be the owner of a taxi service. So it is predominantly lay persons. And by law, the head of the commission is a lay person. It has judicial members, it has judges, but the head is a lay person. Now, everybody in India would think to the appointment of a judge, if you have to see the background of a lawyer practicing in the High Court, the quality of cases he has done, the kind of the ability he has, it can only be seen by judges and by nobody else. But England was an example in which they found that these laypersons will bring some fresh thought to the table. They will bring some detached experience to the table. They will be able to talk about some disadvantaged sections of society in which a judge may not have gone, a judge may not have grown. And I found literature to say that when judges appoint judges, only judges appoint judges. It is not as if that consciously they will appoint particular type of judges. But when a judge or a lawyer looks at another lawyer, whether he is fit for a job or not, they see it from their own perspective and from no other perspective. And some critics have called it cloning of judges. That when you want to appoint a judge, you look at him with what you have been. You compare him with your situations. So it's called either a cloning of judges or they have called them judges. So to do away with that, idea is to have different views. We found in South Africa, the South African rules provide that a woman must be a member of the judicial appointment body. The reason is that women have been deprived of the same number of chances as men have got. And the same position, if I may say so, happens in India. We have one judge of the Supreme Court, sometimes one, sometimes two. There should be many more judges who come from different sections of society. So idea is to have, not to have judges. Now let us examine how judges were appointed under the Constitution. And in fact, what did the framers of the Constitution have to say in the matter of appointment? If you see Article 124 of the Constitution, it says, the President shall appoint a judge of the Supreme Court in consultation with the Chief Justice of India and consultation with such other judges of the Supreme Court or the High Court as the President may desire. This is, in simple terms, 124. Now, according to me, it is as clear as daylight that President, which really means the executive, that is the government shall appoint in consultation with the Chief Justice. That's what it says. So the power of appointment was with the government. But a healthy check and balance from the theory of checks and balances was put in by the framers, that you will not appoint without bothering to consult anybody. You must have healthy consultation with the Chief Justice of India. He is the head of the judiciary. He would know the sources from where the recommendees are coming. He would have some personal experience. He could give you the inputs from different Chief Justices, etc., etc. So that consultation is a must. But consultation remains consultation. That is how it started from 1950. There was healthy consultation. And rarely the views of the Chief Justice of India were ignored. Very, very rarely. In fact, records show, as is reflected in the judgment in the second judge's case, that only in 7 cases out of 547 that there was a discord from the period of 1950 to 1993. So the system worked perfectly well. It produced very, very good judges. But there was, as you know, a period of turbulence and disturbance. That period was 1973 to 1977 or so. In 1973 came the judgment of the Supreme Court in Keshav Bharti, or popularly called the Fundamental Rights case. A 13-judge judgment delivered 7:6. The day the judgment came, there was supersession of 3 judges. Justice Shallett, Justice Hegde, and Justice Grover. So what used to happen in that period was, the moment a judgment would come, the government would react. The moment the government would react, a judgment would come. Then came Indira Nehru Gandhi's case. Then came the emergency. Then came the famous case of ADM Jabalpur, which I must say was the weakest moment of the Supreme Court. The High Court had stood up to the emergency, but the Supreme Court did not. But anyway, the moment the judgment came and Justice Khanna tilted the balance, that he was superseded. So that was a turbulent period, and that led to the first judge's case. The first judge's case was heard by 7 judges. The judgment there is also 4 judges to 3. Despite the turbulent period, the first judge's case stuck to ordinary interpretation or literal interpretation of Article 124 and said that consultation with the Chief Justice of India means only consultation. It cannot mean concurrence. So that position continued. Then came the 1993 case, which is commonly called the second judge's case. This was a bench of 9 judges. This bench said, while interpreting 124, and 124 remains 124, there was no addition, there was no amendment. So this bench said, firstly, that consultation actually means concurrence. I don't know how, by a process of interpretation, you can call consultation as concurrence. But it did so. It also evolved a new body for appointment, and that body was called the Collegium. The Collegium was to consist of the Chief Justice and 2 senior most justices. So the Collegium would do the recommendation and it would go to the executive. The role of the executive, which had the primacy in the matter of appointment from 1950, was thus taken away, and primacy was then retained by the 3 judges. And when they were to make a recommendation, the executive had only a polite chance of saying, please have a relook, because there is some material which you don't have or which you haven't seen. Then came the third judge's case. And why did that case come is very interesting. Mr. Justice Punchi became the Chief Justice in 1998. He had dissented in the second judge's case. He said that the power of the Chief Justice is the Chief Justice alone, and there is no question of a collegium. There can't be 3 Chief Justices. There is 1 Chief Justice, others are judges. So when the law said Chief Justice, it means Chief Justice. And he virtually said that I don't want to follow the second judge's case. Hurriedly, a presidential reference was organized. The presidential reference raised some issues and it came before the court. And I may remind you, Justice Punchi, when he wrote the dissent, he starts by saying that this is an epilogue, as if he is writing an epilogue to a book. And he ends his dissent by saying, was it worth it? So he frames a question and leaves it. So when Justice Punchi was of this view, a third judge's case which was formed out of a reference. The reference came. The reference sealed the fate of the executive. The reference went on further and said, if the executive says, please have a relook, because this recommendee may or may not have proper levels of integrity, because this is some material which we have found. But if the judges' collegium was to say, no, we overturn or we don't regard your objection as valid, and we reiterate this recommendation, then the recommendation had to go through and the person had to be appointed. So from 1950, when the right to appoint was with the government, it was taken away in 93 and cemented in 98. So the role of the executive virtually became akin to that of the President of India, namely a rubber stamp. It is significant to note, and the judge's case did not consider, which was crucial. What did the framers of the Constitution, what did they have to say, or what was their thought when the Constitutional Assembly sat to frame the Constitution? Just 2 or 3 years before 1950, Dr. Ambedkar was the leader. He led the Constitutional Assembly. What were his views? What were views of others? Did they talk about consent? Did they talk about consultation? Or did they mean concurrence? It was obvious. If you read the debates, you will know what they thought and what they put after 2 years. It was as simple as that. The debates are available, but you will find there is some sprinkling of the debates in the second judge's case, but the real debates are missing. They are not there. And I want to read 2 passages which I showed the Supreme Court this time as to what Dr. Ambedkar wanted for purposes of appointment of judges. And did he want an insular body of the Supreme Court where judges would appoint judges? Or did he want a body which will have a sprinkling of the executive and the judiciary? Or would it be an absolutely federalist structure like the US, that you have separate, isolated compartments of the executive, parliament and the judiciary? Our Constitution is not purely federal. There is an intermix. And the intermix you will find in many provisions which I will refer to. But what Dr. Ambedkar said is extremely important, which I want to read. And I dare say, had this been noticed properly, the judgment may have gone the other way. And I'm not reading the whole thing, I'll read only a part, where the issue was that entire power should only be with the judiciary in appointment of judiciary and nobody else. There was one gentleman called Mr. Poker Sahab. He was a member of the Constitutional Assembly. He moved an amendment, change consultation to concurrence. Specifically, Ambedkar shot it down and said that I am not willing to vest absolute power, because consultation to concurrence will mean absolute power of the person whose concurrence is required. In that regard, he said, the draft article, that is 124, therefore steers a middle course. It does not make the President supreme and absolute authority. President means the government here. Supreme and absolute authority in the matter of making appointments. It does not also import the influence of the legislature. The provision in the article is that there should be consultation of persons who are ex hypothesi, well qualified to give proper advice in matters of this sort. And my judgment is that this sort of provision may be regarded as sufficient for the moment. With regard to the question of concurrence of the Chief Justice, it seems to me that those who advocate the proposition seem to rely implicitly both on the impartiality of the Chief Justice and soundness of his judgment. I personally feel no doubt that the Chief Justice is a very eminent person. But after all, the Chief Justice is the man with all failings, all sentiments, all prejudices which we as common people have. And I think to allow the Chief Justice practically a veto upon the appointment of judges is really to transfer the authority to the Chief Justice, which we are not prepared to vest in the President or the government. I therefore think that this is a dangerous proposition. So it was clear from a reading of this that the article was drafted which would show that there is an intermix between the executive and the judiciary. The final power of appointment was with the executive, but consultation was a must. This is what he said. One more passage in this regard is extremely important. The debates are in hundreds of pages, but I have just culled out two. This was one and this is the second. Dr. Ambedkar speaking on 27th May 1949. Sir, there is no doubt that the House in general has agreed that independence of the judiciary from the executive should be made as clear and definite as we could make it by law. At the same time, there is fear that in the name of independence of the judiciary, we might be creating what my friend T.T. Krishnamachari very aptly oftenly called imperium in imperio. We do not want to create an imperium in imperio, and at the same time we want to give the judiciary ample independence so that it can act without fear or favor. So he clearly said that we are not going to create isolated sections or organs, that the Supreme Court will appoint its own judges, will appoint its own officers, will appoint its own salary, will have rules of dismissal itself. That is why you students, if you study the chapter relating to Union Judiciary in the Constitution, starting from Article 124, going up to Article 147, you will find in every article is interspersed the power of the executive, parliament, or the president. For example, the salary of judges has to be fixed by parliament. The procedure for impeachment is under the Judges Inquiry Act. The framing of rules of the Supreme Court under Article 145 also require the consent of the President. So it's not a single unitary system that the Supreme Court or the judges will appoint themselves, etc., etc. So that is how our Constitution is framed. It is not purely federal. There is an intermix between different wings of society. So the second system of appointment of judges then started with the collegium. Now the collegium was conceived by a judgment. There is no law which says that there will be a collegium. So the collegium of 3 people was enhanced to 5 by the 3rd judge's case, insofar as appointment to Supreme Court was concerned. So where is the procedure? There is no procedure prescribed. There is nothing in the rules. There were no executive instructions. So a procedure which had some in-house systems started operating. This meant, and we have all been lawyers at that time, nobody knew how many vacancies are to be filled up in which high court. There was no advertisement. The lawyers didn't know. We just used to hear rumors that so-and-so's name is being considered. There was no criteria whether a lawyer should have 100 appearances, should have appeared in 100 cases, should have income of so much to show that he was reasonably popular. So there was no indicia. There was no publicly declared process. There was no way anybody could apply to being a judge of the High Court. In today's times, in England and other places, people can make an application to be a judge. There is a criteria. You fill up the criteria. If you fulfill the criteria, you will be considered. So this is how that system went. It was in kind of closed doors. The collegium of the High Court will recommend some name. It will come to the Supreme Court. There was no interaction with the bar. Really no interaction with eminent lawyers practicing in the bar, either in the Supreme Court or the High Court. And in this method which was clouded or shrouded in secrecy, without a publicly declared process, that people were appointed. I am not saying the appointments were bad. I am only on the system or the process. We have had good judges also in the last 15 or 20 years. But this kind of process in a situation when today you have the Right to Information Act, everything must be transparent. So the system lacked transparency, it lacked criteria. Criticisms started. Judges of the Supreme Court have criticized. And one very strong criticism publicly declared was by Justice Rumapal when she delivered the V.M. Tarkunde lecture in Delhi a couple of years ago. And she said, and I remember, that the best kept secret in India is the way the collegium functions. So she may be right, she may be wrong. There is huge criticism in Mr. Sirwell's book, a very well-known author. Even Justice Verma, who was the author of the judgment, gave an interview to India Today and said, my judgment is being misunderstood by the Supreme Court itself. I did not mean that the executive will be completely out, etc., etc. Justice Krishna also wrote something about it. Late Justice R.M. Sahai of the Supreme Court also wrote something about it. So the criticism was mounting. I am not for a moment suggesting that the judges of the collegium appointed people in bad faith, etc. I am sure they appointed people in good faith. It is an additional responsibility of the judges of the Supreme Court. But since the process lacked transparency, that there was a hue and cry over this process. The collegium has no record, and we saw it in this case. Files were called. We produced the files of the collegium. There is no record of discussions as to how people were compared. So if 6 names are considered, 2 are allowed or 2 are recommended, nothing was done. No record. So it is in this backdrop, public criticism, backdrop, discussion for the last 25 years in Parliament from 1990, that these laws were passed. Now what does the new amendment and the NJC Act in a nutshell say? I will put before you in simple terms. The Constitution Amendment changed Article 124 and said, not that President will appoint in consultation with the Chief Justice. It brought in the concept that the appointment shall be by a body called the National Judicial Commission. It will consist of 6 members, as I mentioned. And it said that the appointment shall be on the basis of ability and integrity. It also mentioned that one of the 2 eminent persons will be from the group I mentioned, whether SC, ST, women, etc. The procedure for appointment is to be found in the NJC Act. There is one interesting thing in the Act which was a matter of much debate. As you now see the bodies of 6 people, normally the bodies of uneven number, so that the majority prevails. Because majority is the normal rule. But this is a body of 6. So simple majority cannot work. 3:3 cannot work. So the Act provided that if any 2 persons out of 6 say no, then the appointment doesn't go through. So you require 5 affirmative votes out of 6, something like 90%. You require 5 affirmative votes out of 6 for the appointment to go through. And if 2 say no, whether it be 2 eminent who say no, whether it be 1 eminent and 1 judge, whether it be 2 judges, because it is not expected that all judges will speak in the same voice. They were entitled to have different voices. Or whether it is a law minister and a judge, or a law minister and an eminent, there could be many combinations. But if any 2 said no, it's a kind of a veto. So the appointment doesn't go through. This was a matter of much debate. The other side argued, and the court put to me that look, if 3 judges say yes, having 1 more person saying yes, so let us say 3 judges and the law minister say yes, how is it possible that 2 eminent people should be able to block it? Would it not, hit independence of the judiciary, etc.? So anyway, we gave our submissions that one should not take it as an affront. If 6 people are sitting in a body, the vote of the eminent person is as good or as bad as the vote of the Chief Justice. But if you are going to give him half a vote, then no eminent person will come and sit on the same table, because he will say it doesn't matter. Because if the Chief Justice or another judge has to get a casting vote, then why should I come to the table? And things like that. So, all that was shown to the court and argued. And incidentally, it will be interesting to note that even in the collegium system of 5 judges, if 2 judges were to say no, then the appointment doesn't go through. So I pointed out to the court that if it was good, if this point was good in your system, then this point should be good in this system also. It can't be that 2 judges will say no and that's fine, but 2 people will say no here and it will not be fine. So that's one major issue. And you will find in America and in England, this kind of higher majority, 2/3, 3/4, 80%, 90%, they call it supermajority or special majority. And the idea is, the more significant the decision, the higher you go above simple majority. Simple majority can be 51-49. But if the issue is so important, don't be content with 51-49, go higher, 2/3, 3/4. And there are examples galore in the Indian Constitution and in our statutes where the position is higher. For example, impeachment. Impeachment is 2/3. Amendment, Article 368, 2/3. Ratification of states. So you can have different things and different requirements rather than mere majority, etc. Now let me tell you at the end, I have taken enough time.